Happy Sunday evening. It's about 8 o'clock right now, and we're going to get through this presentation right here regarding Anderson and King County. In the last 20 minutes or so, I realized that I'm a lot more comfortable in speaking live to people than recording myself, because if I make an error, I can't just go back 3, 4, 5 seconds and repeat it, especially with a video format. But we're going to work through this and have a good time at this. Okay, 2006, Washington State went through a court case called Andersen versus King County. Andersen versus King County, during the Supreme Court for Washington State, focused on about 14 different plaintiffs. There were several couples consisted of gay and lesbian couples that tried to appeal the same-sex marriage laws which the United States eventually passed. However, back in 2006 in Washington, the question was brought up of same-sex marriage should be equal to opposite-sex marriage or man and wife marriage. So we're going to focus on it, talk about some of the history about it and how it came about, and then we'll focus on what the court actually said and some of the opinions on this court. So, as I mentioned, that gay marriage advocates were really looking for a favorable decision to happen at that time in 2006. And they're hoping that Washington State would support them and boost it nationwide, that hopefully a ball would get rolling and a bunch of the other states would start jumping on board to helping out support gay marriage. However, the opposite happened. When I first selected this, and I was hoping that this whole document in court case would be in support of gay marriage, the actual document in court case actually, spoiler alert, wasn't. The plaintiffs here went to court in King County and they lost. They appealed it with an appellate court, a trial court, and the appellate court actually won the case in favor of same-sex marriage. However, the opinion was then given to the Washington Supreme Court, who looked at it, and in this entire opinion, from the justices, it overturned it and said, no, it doesn't meet the requirements. So before we got into this, we need to address what you see right now on your screen regarding the civil rights issues that are trying to be contested by the plaintiffs. Basically, they're challenging the state of Washington on constitutional limiting marriage only to same-sex couples. It addressed, the court case addressed sexual orientation, and it wanted same-sex couples to marry just as opposite-sex couples are wanting to marry. And one of the issues or the points of note that the plaintiffs were trying to focus on was under the Declaration of Rights, under the Washington State Constitution, saying that persons' rights under Article 1, Section 3, you can see on your screen, that no person shall be deprived of life, liberty, property, or due process of law. So the way they understood a lot of it was that there should be equal treatment about all people, because life and liberty, property, and due process of law. Part of the due process of law has already said that people should be able to get married. Now, before this court case, what really brought about this issue was in 1996, there was state laws were passed and then federal laws were passed, as you can see on your screen, by President Bill Clinton at the time, and it was called DOMA, the Defense of Marriage Act. What DOMA really focused on is determining the definition of what is a marriage and who's involved in a marriage, and the definition of spouse. So, according to DOMA, in determining the meaning of any act of Congress, so any act of Congress, not just we're defining this little portion, marriage, compared to all the relative laws that are available, but any act of Congress or of any ruling, regulation, interpretation of the law of the various administrative bureaus and agencies of the U.S. So everything that's ever been or it's going to be written that focuses on a family unit, a spouse, or marriage, at that time, based on this ruling, the word marriage is going to mean that it's only a legal union between one man and one woman as a husband and wife. And the word spouse refers only to a person of the opposite sex who is a husband or wife. So if I'm a husband, my spouse would have to be a wife, and if I was a female, my spouse would have to be a husband. By this act alone that was passed by President Clinton, it had many detrimental effects and long-term consequences from then on. Because as we know now, looking back several years, many court cases are brought about regarding equality in marriage. And unfortunately, this case between equality and marriage is nowhere near identical as equality dealing with race or just sex or gender specifically. Whereas saying that people who are black or Hispanic or Asian and white are all equal, that's correct, they are. But the lawsuits in the cases referring to this were much different than the court decisions regarding this. So we're going to keep going. To continue with the Defense of Marriage Act, which focused again on same-sex couples from marrying, the Chief Justice who wrote for the plurality of the court's majority, the 5-4 decision in the article we had to read, talks about that state legislature in Washington is allowed to limit marriage to opposite-sex couples for further procreation. Since same-sex couples cannot procreate, cannot have children, only opposite-sex couples can have children, it's essential to the human race. So Justice Madsen's purpose on this focused on the continuance of life and also the well-being of children by encouraging the families where children are reared in homes should be headed by biological parents. Yes, the arguments were made, and we'll get into that regarding adoption and regarding non-biological parents and things like that. But some of the arguments within this court case were not brought up properly to address those issues even. So, according to Judge Madsen's argument, that DOMA is not a violation of Washington State's Constitution because the Defense of Marriage Act doesn't discriminate against women or men. It's actually equal. What it says is, as you can see on your screen, is a woman cannot marry another woman and a man cannot marry another man. So therefore, it doesn't discriminate between men and women. As this court case moved on, and yes, greatly it was overturned. Eventually it was overturned, and now, luckily, people are able to marry who are same-sex. But at the time of this case, based on some of the writing within this court case, it wasn't possible. Regarding some of the facts of this court case in Washington '98, marriage licenses were denied to same-sex couples. Couples approached the courthouse trying to get the clerks to provide paperwork and help them out, but since after DOMA it was illegal for same-sex couples to be married, they were denied those marriage licenses. Plaintiffs then, for this case, the couples who felt that it was an injustice and they wanted to be married, petitioned the court indicating that it stated the violation of the Constitution of the state, which should provide equality and liberty and privacy to all of its citizens. But in this case, it didn't seem to have provided those things. Part of the court's procedure in order to determine whether this court case was factual, valid, and provided any type of unconstitutionality was it had to create a three-pronged system to determine the protection analysis requirement. One of those would be the class, which in this case would be people who happen to be homosexual, have suffered a history of discrimination. Now, By no means did the court or anyone say that there was never any discrimination against people who are gay or lesbian. That wasn't the consideration at all. Of course, it was addressed even in the brief. The judge wrote, Judge Madsen wrote that there is no dispute that gay and lesbian persons have been discriminated against in the past. So of course it did happen, but the entire class must have shown that there is a history of discrimination. For comparison, let's look at people who are African American. When we're focusing on slavery and discrimination for racial bias, we know that in history that there were many blacks who were slaves. And because of that, the entire class, the entire population of the blacks that were here were put into slavery. So the entire group of people had the discrimination put onto them. Whereas with people who are lesbian or gay, it wasn't the discrimination on all of them. The second prong talks about how the characteristics of the class must have an immutable trait that frequently bears no relation to the ability to perform or contribute to society. So whatever is part of them, it's immutable trait, it's part of their innate core, has no relation to the ability to perform. Basically, people who are homosexual can still have the ability to work. It doesn't bear any hindrance. At the time, once again relating to people who are black, people who were black and women, let's look at women's rights as well, were considered a lesser class at the time. So there were segregated workplaces where blacks couldn't work or women could work in this field. That kind of immutable trait showed that there was a problem from allowing that class of people to work with other classes during women's rights movement. Women wanted to work with men, weren't allowed to, and that's where the discrimination came in. Same with people who were minority of color or race, wanted to work with the larger race, which happened to be white people, weren't allowed to because they were discriminated against. And that's how this class became a suspect or protected class. And the third prong on here is showing that a minority or a politically powerless class. As we know in history, people who were minority racial or women at the time, before the women's rights movement, didn't have much political power. They looked down upon and weren't given a lot of credence to what they were saying, and no law supported it. Well, as we know over time, that people who are gay and lesbian are increasing their political power many times over. There are many people who are in Congress, who are in high places of business, who are leading companies who happen to be gay or lesbian. And so the support is always there. However, that hinders them being defined as a suspect class. The court then looked at some of the fundamental rights regarding the Constitution from the state of Washington. So some of the constitutional rights in the analysis had to be considered as deep-rooted national history and traditional rights that are implicit in the concept of order liberty. They're neither liberty nor justice would exist if they're sacrificed. So these fundamental rights are something that the founders, the writers of the Constitution, had to identify as being protected. You know, freedom of liberty and life and the pursuit of justice, things like that. To describe some of them, as you see on your screen right now, some of those fundamental rights include the rights to marry, to have children, to direct the education and upbringing of one's children, marital privacy, the use of contraception, bodily integrity, and abortion. Those fundamental rights, of course, have been always contested, and they've been added to and adapted over time. In the last few weeks, we've read court cases that have dealt with use of contraception and women's rights to abortion and even the right to marry and to have children. So this is one of the the main pillars the court had to look at in order to determine whether the fundamental rights were violated regarding someone who wanted to be in a same-sex relationship. The second part of this pillar was that the history and the tradition that we've noticed over time are not static. We clearly see that as time goes, the Constitution, society, community, we evolve, we change. We find new things that bond us and that we share, and the government and its laws have to become part of that system. They must adapt its laws. They must adapt and understand the necessities for society to advance. In 1967, interracial marriage, for instance, was violated, equal protection and due process. So interracial marriage at that time was looked at as not being a fundamental right to marry. But they determined that it doesn't affect anything. Being married to somebody of a different race does not affect anything as far as procreation, does not affect anything in law, does not hinder the government or society's ability to evolve. So the points that were made in that court case were able to overturn the rules regarding interracial marriage. One of the other subjects that was looked at was a rational basis review within the courts. The plaintiffs in this case who filed this appeal and filed this court case, during it they failed to establish that gay and lesbian persons constitute a suspect class based on the following two factors: that there wasn't any type of animus. Animus is defined in court as an intentional discrimination by the people who make the laws within the law against people in that nature. However, the plaintiffs claim that Washington's DOMA, the Defense of Marriage Act, is unconstitutional because it was filed intentionally to discriminate against gays and lesbians. They even mentioned that one of the prime sponsors of the act said that legislatures only openly gay member that homosexuals should be put on a boat and shipped out of the country. That's horrific. However, one statement alone does not prove that the law, that DOMA, was created intentionally to stop people who are same-sex from getting married. And the burden, under presumption of invalidity, the burden also shifts to the government to prove that the same decision would have been made absent of the discriminatory purpose. What this means is that would the same court case have been filed, or would DOMA have been enacted, had there been not anyone who was homosexual? Would the court case have been created in lieu of those actions? And that was one of the things that had to be looked at. And unfortunately, the plaintiffs, during this Washington Supreme Court hearing, didn't provide that information, didn't provide an argument for this. Another part of the rational basis review was that the discrimination against a class in and of itself doesn't make the class as a protected class. What the court was saying, what the Supreme Court here in Washington was saying, is that just because somebody within the court dislikes or may discriminate against a certain person who is considered different or has a different gender, different race, religion, creed, does not necessarily mean they're a protected class. To break that down, just because I'm left-handed does not make me a protected class, because I don't meet those three prongs to identify that I'm left-handed and therefore I'm lesser of a person or I'm discriminated against. True, the argument can be made that there are items, kitchen knives and scissors, that are made for right-handed people, whereas I'm left-handed. It's a little more complicated for me to use things, but that doesn't necessarily say that there are laws that are purely written against us left-handed people and we're now a protected class. The government had to create a purpose to discriminate against same-sex marriage, and that's what this court opinion is actually based on. After reading this entire article and creating and analyzing it and determining that the court overturned the appeals court decision and held that DOMA was constitutional. It was not an unconstitutional act because the state's focus is on procreation between sexual relationships of heterosexual partners to have children, and children are a probable result of heterosexuals having consensual sex and giving birth to children. And same-sex marriage just doesn't further the state's interest at the time. Now, some of the comments making regarding this, of course, sound anti-homosexual rights, but remember, this is an older court case. So nowadays, this isn't the fact anymore. But at the time, same-sex marriage just didn't benefit anything from the state. So the state determined that they shouldn't change the laws just because somebody wanted to be married of the same sex. There's no real need to do it. The plaintiffs in this, however, maintain that procreation itself does not hinge on any type of marital status. What this meant is that I don't have to be married to somebody to procreate. Just because I'm married to another male does not mean I can't technically procreate with a female using artificial insemination, in vitro fertilization, or even having sexual relationships with a female in order for procreation purposes only. All that was at stake here is the ability to be married in a legal and lawful ceremony. One of their arguments that was made by the plaintiffs was that infertile persons are allowed to marry as well. They're sterile and elderly. So why should someone who happens to be a homosexual be punished and not be allowed to marry? They're stating that a person who can't give birth because of sterility is still legally allowed to marry, and that is therefore attacking their sexual orientation. Another part of this was that married couples are not required to have children. So if a homosexual couple who chooses not to have children is being faulted for not being legally allowed to marry under the grounds that procreation is necessary, but a heterosexual couple, an opposite-sex couple, is not required to have children for procreation purposes, and they're not punished by any type of law. And just because a homosexual couple is married, someone who's gay or lesbian is married, does not prevent them from adopting any children. We all know that children are often given up. There's a lot of people that do not want children, but there are many couples that cannot have children that want children. So adoption agencies are able to assist them with having children. And there are those couples who happen to be homosexual or gay or lesbian that want a child, and because of the value of life that they're willing to place on a child and give them a home, give them shelter, give them love and affection, they should have the ability to have that child and be able to adopt one. So the reason this case was overturned from the appeals court was that the justices determined that the plaintiffs never established that sexual orientation is a suspect classification. They weren't a protected party. So saying that they were discriminated against, as I mentioned earlier in this discussion, in this video feed, that it wasn't discriminatory because it focused on both men and females. Men can't marry men and women can't marry women. So they addressed both genders. And it wasn't just men cannot marry men, but women can marry women. It focused on both equally. They also have that they have a fundamental right to same-sex marriage wasn't addressed. The way a lot of this court case was worded is in comparison to other cases which focused on other states' constitutions and their rights, or some of the arguments that were made within this case focused on discriminatory actions towards other protected classes such as race or religion, but not focused on homosexuality. And therefore, based on those, there was no rational basis of justification made that opposed procreation and the well-being of children. The court held that the states needed to focus on procreation and the well-being of children. DOMA, therefore, was still listed as constitutional at the time because it created to codify common law. It created a basis for identifying what a spouse is, what a husband and wife union is. It promoted the procreation, and based on the government's ideology, it promoted safe families. Thank you for listening to this brief video regarding Andersen versus King County in Washington State in 2006. It's my first time doing a video recorded session, and I do have to say it's a little more daunting than I thought, and I hope that as we continue throughout the semester I can improve on this and enjoy myself even more. Thank you guys. If you have any questions, once again, my name is Rolf Kotulla. You can email me at rkotulla@patriots.uttyler.edu. You guys have a good night.